I'd like to introduce our first speaker, Professor Mark Templeton, Clinical Professor of Law and Director of the Abrams Environmental Law Clinic. He has worked extensively in leading and developing improvements in energy, environmental protections, and water resources. I will now turn over the program to Professor Templeton, who will provide an overview of the clinic with the help of 3 of our very own law students on the environmental issues our world faces today.
Great. Thank you so much, Swapna, for introducing this. It is so wonderful to see so many familiar names and faces of people who've been really interested in the work of the clinic over the past few years and incredibly supportive of it as well. So I'm grateful that you all are taking time out of your very busy schedule these days to come and hear an update about what we're working on in the clinic. So I'm just going to advance here. Today, I'm going to provide a very brief overview about the clinic, but then I'm going to get out of the way because the work of the clinic is work done by the students. And so I want them to share with you the work that they're doing in their own words. And so this is an event focused on our work in the clinic on our energy work. And so we're going to talk about 2 different pieces of that energy work. The local work that we're doing in Michigan, in and around Detroit. And then we'll talk about some of the other work we're doing at the federal level related to greenhouse gas emissions. Daniel Abrams will also, Camille will talk about the local work. Justin will talk about the federal regulatory and global work. Daniel will talk about the student experience. I'll say a couple of additional words about some of the other projects that we're working on and what student trajectories are like after the clinic. And then we'll definitely have some time for your questions. So thanks to those who sent the questions before. I'm also hopeful that we'll generate some questions from the audience as well that we'll address. So let's get going. So the Abrams Clinic started almost 9 years ago. And it's one of about a dozen in-house clinics at the University of Chicago Law School. Unlike other law schools, we have a pretty strong belief that the clinical experience is best delivered by full-time clinical faculty who are on the faculty at the University of Chicago Law School. I founded the clinic almost 9 years ago. My colleague Rob Weinstock, who's here also, and Rob should wave if people can see him. Joined about 4 years ago as an integral part of the supervisory aspect of the clinic. And so Rob and I work with about 20 students every quarter, and many of those students are enrolled for multiple quarters. They receive academic credit for their work, and they're taking the clinic and putting in a lot of time on top of a pretty heavy course load that they may have in other extracurriculars like journal and other things like that. The clinic is designed to give students this kind of in-role experience, to really put them in the role of being an advocate. Obviously, Rob and I help to guide them. We use methods not unlike you might see in other classes where we'll ask the students, so what do you think should be done? Kind of a quasi kind of Socratic method to get them really thinking about how best they can, what are their clients' interests generally? How does this particular project, whether litigation or policy, kind of fit into that? Where are we in the process? How can we kind of best advance that at the given moment? So these are real live controversies, and our policy work is really live, also designed to influence governmental decision makers. And again, as I was starting to allude to, there's this kind of clinical, there's this mantra in clinical education: plan, do, reflect. I think in practice, we're often just doing a lot of doing. Something comes in, it's got to get done. Then we're on to the next thing to do. Maybe there's some planning, right? If we're being thoughtful, we sort of say, okay, how does this fit into the next piece of work? How can we get ahead of things and not be behind and really help our clients? We also really try to emphasize the reflection piece. What went well? What could have gone better? Both in this individual case and what does this teach us about the skills that we need to work on? And frankly, even though I've been doing this for many years, I benefit from the feedback that I get from the students too, in terms of how we can do this better and deliver better service to our clients. So now I want to let the students have really the in-role experience and talk about their experiences on our local work in Michigan, on our federal regulatory work, and then hear about a sum up of the student experience as well. And so we've planned, and now we're about to do, and then we'll reflect afterwards. So Camille, can you take us away on the Michigan work, please?
Thanks, Mark. My name is Camille Sipple. I am a 3L at the university right now, and I have been in the clinic for 3 quarters. I am on the Michigan Energy team, which is what I'm going to talk about today. So our client is Solidarity, which is a nonprofit based in Michigan. It was founded when the local utility DTE ripped more than 1,000 streetlights out of Highland Park, Michigan, something that frankly benefits no one. And this group formed basically to advocate for people-powered clean energy, which can range from solar-powered streetlights to the development of community solar, to all sorts of advocacy that surrounds energy democracy. They also advocate for affordability, people saving money on their energy bills, and then their main goal is to just build a just and equitable energy system for all of the residents in that area. I'd also like to mention that a little bit of background about this area and then DTE in general. Highland Park, Michigan is a pretty low-income neighborhood. The majority of residents are people of color. And when DTE ripped these streetlights out, the community really came together as one. DTE is located in Michigan. Obviously, it's one of the biggest regulated utilities in the state. They make about $12.7 billion per year and serve some 2.2 million customers throughout Southeast Michigan. So when we're going into these proceedings, we are often sort of the David versus Goliath. DTE is Goliath and we are David, and we're always going up against the big DTE company. In these proceedings, when we are going into these proceedings, we're always at the Michigan Public Service Commission. And the Michigan Public Service Commission is a state panel of 3 appointed commissioners, and they are supported by an administrative law judge and staff. Their mission is to basically ensure safe, reliable, and accessible energy services for the people of Michigan. And every time the MPSC rules on a decision or a program, those orders serve as precedent for us when we go into the next case. So each case sort of builds on each other. And when we go before the MPSC, Solidarity has a couple of focuses, and we usually have sort of a string of arguments that we commonly make or bring up in these proceedings. Our main point is usually focused on energy democracy, which has a couple different aspects. The first is low-income access to renewable energy, and that can mean affordability, monetary access, or it can mean actual access to the renewable energy within their communities. So renewable energy can be wind farms thousands of miles away, but what we really advocate for is like community solar, renewable energy systems that the community can actually have within the communities that they live in and be involved with. The other thing we usually advocate for is community and stakeholder involvement. And so that means that people get a say in any sort of decisions that affect them. We really try to ask that the Commission and DTE include both our constituents and other parties that may be involved in the conversation. We also continually advocate for consistently better public health initiatives. There are a lot of benefits of solar and wind and renewable energy systems. And we also ask that those be put in communities that have historically experienced dirty energy and the effects of dirty energy. And finally, we also advocate for distribution, safety, and reliability. Many of these low-income communities experience disproportionately downed wire incidents, which means that wires can injure or kill people when they fall down during storms or otherwise. And then they usually experience disproportionate outages and lose their electricity more often, even though they're often paying the same prices as other constituents. So NPSC proceedings are incredibly long and complicated. So they go through all these steps every time, and each case that we go into is sort of a different piece of the puzzle. So right now, we're starting a new proceeding, and these are sort of the steps we have taken. So we plan for the case, we move into discovery, and then we get direct written testimony, working with various different individuals. We write the brief, we write a reply brief, then the ALJ issues a proposal for decision. Then we move to exceptions and replies to exceptions, and then we finally get the commission decisions. Then if we don't like that decision, we could potentially appeal it, and if not, then we just move on to the next case. And all of these cases sort of take us a step forward into the process, and each time we get a little bit better. So what we are kind of working on now. So we have two sort of cases we're focusing on now, the voluntary green pricing case and COVID-19. So I recognized earlier maybe community solar kind of seems like a foreign concept, but community solar is basically putting solar panels maybe on a building or in houses in a neighborhood, and the people that live in that neighborhood can actually subscribe to that renewable energy program. The voluntary green pricing case is all about how low-income consumers and consumers more generally can subscribe to different renewable energy programs. The specific one we're arguing about is the one that DTE offers and is required by the state of Michigan. But we are always arguing for more options, more choices, and usually lower prices. So people have more control and power over the energy that they want and can subscribe to. During COVID-19, we also had several case dockets open, working on the different aspects of how the energy system might be affected because of COVID-19. There may be cases arguing about rates for customers because there might have been some monetary losses due to COVID-19. There can be severe public health effects if the electricity goes out during COVID-19. People could lose the food in their refrigerators or experience different aspects of health that they may have to go to the hospital for during a pandemic. And so we kind of have touched on all those things during our different proceedings, and we are preparing for future cases that will maybe results of that. So we're preparing for a possible rate case, another possible distribution case that will discuss different aspects of the energy system. And we're also constantly engaging in stakeholder processes and research. So right now, we are working on a stakeholder process that is discussing how to improve the distribution and resource planning of DTE. And then we're also working on a joint report with UC Berkeley that would help us sort of combine our resources and find the best ways to approach new aspects of cases. So finally, on the right here, you can see Jackson Copel. He is the Executive Director of Solidarity, and we get to work with him honestly on a week-to-week basis. We talk to him almost weekly, and he is a great client to work with. And we've recently did an article for the law school, and he talked about how much he liked working with us. So we thought we'd include that here and just show you that we really enjoy working with our clients, and hopefully they also enjoy working with us. I will now pass it over to Justin to talk about the social cost of carbon.
Great, thanks so much, Camille. Hi everyone, my name is Justin Telesnik, and I'm a 3L at the law school. This is my second quarter in the clinic, and we just talked a little bit about the clinic's local work through our work in Michigan. Now we're going to zoom out a little bit and talk about our work at the federal and even global level, talking about our work regarding the social cost of carbon. So before getting into what our team does exactly, I thought it might be helpful to talk about the social cost of carbon itself. The social cost of carbon is defined as a monetary estimate of anticipated climate change damages caused by an additional ton of CO2. And what this sort of technical definition means in normal English is that it's a way to quantify the otherwise sort of nebulous risk associated with carbon dioxide emissions. This metric, the social cost of carbon, has been refined over years, resulting in a widely accepted science-based metric that we hope will be used in many different decision-making processes across government. The social cost of carbon is one of the best tools at our disposal for estimating the future harms associated with climate change. And this metric was developed after modeling over 150,000 scenarios. So it's an incredibly robust model of future harms associated with climate change. So why does the social cost of carbon matter? First, the federal government promulgates and puts forward dozens of rules, makes hundreds of decisions, including permitting decisions, that affect the amount of CO2 released into the atmosphere. And these decisions collectively cause hundreds of billions of dollars in climate change related damages. Second, these rulemakings and decisions often require agencies to produce cost-benefit analyses about their proposed regulation or decision. And we want regulators to rely on the social cost of carbon to quantify the benefits and costs of a given regulation. Finally, we have NEPA, the National Environmental Policy Act. NEPA requires scientific integrity in environmental analyses, which includes rigorous analysis of environmental and climate impacts from proposed permitting and leasing decisions. So let's talk a little bit about our client and our role in this important effort. So we represent Professor Michael Greenstone, an economist here at the University of Chicago who has incredibly deep expertise in environmental economics. Professor Greenstone is one of the creators of the social cost of carbon. In government, as a member of President Obama's Council on Economic Advisors, he helped refine the social cost of carbon and integrate it into policy analysis across government. Moving a little bit onto what exactly we do on behalf of Professor Greenstone, we in the clinic file amicus briefs in lawsuits challenging agency rulemaking and decisions that incorrectly apply the social cost of carbon. And our work on behalf of Professor Greenstone brings a uniquely UChicago perspective to the litigation. So while a lot of these suits and challenges involve many parties making many different arguments, few have the law and economics sort of chops to make nuanced economic arguments with authority that only Professor Greenstone can bring. We also felt that we'd be letting down our university reputation a bit if we didn't try to internalize the externalities of carbon emissions, just like we're all taught in 1L torts. So today I'm going to talk about a few of our efforts challenging federal rules and permitting decisions for incorrectly using the social cost of carbon. The first challenge that I'm going to talk about is our amicus brief that we filed in the DC Circuit last spring, challenging the so-called Affordable Clean Energy Rule, which deals with coal power plants. So in 2017, the Trump administration EPA announced its intent to repeal the Clean Power Plan, which was a President Obama regulation. And in 2019, the EPA announced that it intended to replace it with a new rule, the so-called Affordable Clean Energy Rule. This new rule loosened emission standards for power plants, which had the obvious effect of releasing more carbon dioxide into the atmosphere. So a group of states, municipalities, and environmental interest groups brought a suit challenging the rule in the DC Circuit, arguing, among other things, that the EPA violated the Clean Air Act and the Administrative Procedures Act when it repealed the Clean Power Plan and replaced it with the Affordable Clean Energy Rule. On behalf of Professor Greenstone, we at the clinic filed an amicus brief arguing that the agency acted arbitrarily and capriciously when it disregarded the best available science for calculating the social cost of carbon. So this slide is just kind of intended to show the scope and importance of the clinic's work in this area and the importance of the litigation that we were involved in. This case and the associated rulemaking garnered national news attention in major press outlets. If you could, yeah. And it even got some attention about the clinic itself and our work specifically in this litigation, with a little bit of help by author Mark Templeton. So what were the arguments that we made in our amicus brief in the ACE litigation? We first argued that EPA ignored the global harms, counting only domestic harms from carbon dioxide. So for example, the Trump administration failed to consider the fact that harms that occur abroad also have impacts on US citizens and US interests. Second, we argued that EPA misused discount rates, which misleadingly deflated the present day value of future emissions. So this is sort of a technical argument, but the choice of discount rates greatly impacts the estimate of total damages, as the next slide will sort of show. And finally, we argued that EPA underestimated the costs of high impact events. So while we don't know exactly how much climate change will impact the future, we argued that EPA needed to at least consider what would happen if climate change turns out to be far more damaging than anticipated. This chart shows just how different the two approaches are in terms of calculating the social cost of carbon. So by ignoring global harms and using the wrong discount rates, EPA underestimated the costs of the proposed regulation. EPA estimated the harms to range from roughly $1 to $7 per ton of CO2, whereas we estimated that the harm was closer to $53 to $78 per ton of CO2. And just to wrap up this section on the ACE litigation, I'll note that oral argument before the DC Circuit just occurred 2 weeks ago and that we are still awaiting a result. Moving on to our big project this quarter, I'll talk a little bit about our work in the litigation challenging the Trump administration's Safe Vehicles rule. So the Trump administration promulgated the Safe Vehicles rule, which had the effect of lowering vehicle fuel emission standards and efficiency standards. Our team is working on an amicus brief challenging the Safe Vehicles rule, which sets fuel efficiency standards through 2026. And in this case, we'll likely make similar arguments as we did in the ACE brief, namely that the EPA ignored the global costs of CO2 emissions and that they used the wrong discount rates to calculate the social cost of carbon. So in addition to our challenges to large federal rulemaking, large regulatory decisions, we've also been involved in individual permitting decisions as well. So we filed amicus briefs in suits challenging individual permitting and land use decisions. So for example, we've challenged coal mining permit decisions in Utah and Montana. And although the arguments are slightly different in this context and have slightly different legal hooks, our approach remains largely the same. Mainly that we argue that government entities have failed to properly calculate and evaluate the proper social cost of carbon. Together, these rules and permitting decisions, regulating power plant emissions, vehicle emissions, regulating land use, these decisions cover a large share of total domestic carbon emissions. And the clinic plays a critical role in these challenges. We encourage agencies to use the best available science in making policy decisions, and we leverage Professor Greenstone's expertise as an economist to shape the litigation outcomes in ways that the plaintiffs cannot. And the plaintiffs in these cases really rely on the clinic to make nuanced, thoughtful arguments about the social cost of carbon in incredibly high stakes consequential litigation. And just to wrap up, I'll quickly highlight what one of the leaders in environmental law and one of the leading Clean Air Act litigators has said about our work in these different challenges to rulemaking. Sean Donahue, a graduate of law school, and also, as I mentioned previously, one of the leading Clean Air Act litigators, has said really nice things about our work in the ACE litigation. There's a lot here in this long quote, but to highlight one part, quote, "The clinic's work was outstanding and the amicus brief will be a useful resource as the social cost of carbon continues to be a central issue in legal and policy discussions." Thanks so much, everyone. And now I will pass it off to Daniel Abrams to discuss the student experience in the clinic.
Thanks, Justin. My name's Daniel. Good to see everyone today. I'm a third-year law student, and this is my fourth quarter in the clinic. I'm a clinic lifer as of now. I'm going to talk today about the student experience, starting with the fact that our clinic is on the cutting edge. You've already heard a little bit from Camille and Justin, but we're working on the most important cases in the most important venues. So that includes environmental justice cases. One unmentioned case so far, we're working on a lead remediation and Superfund site in East Chicago. We're also working on renewable energy, like Camille mentioned, in Michigan. And then there's the climate change work, as Justin mentioned, with social cost of carbon. But in addition to that, there's also federal clean water litigation, Endangered Species Act litigation. It's a little bit of something for everyone. Big tent. The best part about the clinic is that it's driven by students. Just in my own experience in the last 4 quarters, I've worked on a cross-examination in front of the Michigan Public Service Commission in the project that Camille mentioned. And I'm writing an amicus brief, or working on a team that's writing an amicus brief in the Ninth Circuit, protesting a coal mining expansion. The cross-examination was a pretty cool experience. It was about maybe 1 month into my time in the clinic, and I barely knew what a cross-examination was, and I was sort of pushed to the front of the line. And I got the opportunity to overcome an objection by opposing counsel over introducing some confidential information, and cross-examine a high-level DTE executive about some of the choices they made in their integrated resource plan. And then the amicus brief, I personally drafted most of the procedural motion to get the amicus brief accepted. And I'm working on a team that's really trying to push some important social cost of carbon work in front of the Ninth Circuit, which should be favorable to the arguments we're making and could set some really important precedent in the field. I promise you, Mark and Rob did not pay me or coerce me to create this slide, but the fact of the matter is the clinic is my favorite place at the law school. We get to work with like-minded students. I've worked with Camille on the Michigan Energy Project. She's probably tired of me because we were also together in the Environmental Law Society. And I've also worked with Justin on this social cost of carbon work we're doing. But my experience, I was in the workforce for a bit, and coming to law school was sort of a bit of a culture change, a lot of a return to academia. I felt most comfortable in the clinic environment where, like Mark has said, we're really put in the role of an associate working with partners on really important and practical work. Just from my own experience, I really enjoy the clinic because the quarter system, there's a start and an end to a quarter, but clinic work doesn't end when the quarter ends, and it doesn't end when school's out in the summer. And I appreciate that we're able to pursue our work beyond the bounds of that amount of time. At the same time, Professors Templeton and Weinstock keep it fun. Our meetings that we have once every week are relatively loose, but they also exude a confidence and an ability to get down to business when it's time to get down to work. And the last thing I'll say is that from the moment I expressed an interest in environmental law and pursuing a career in environmental law, both Professors Templeton and Weinstock were invested in that future for me, and doing everything they can to help me network with people and really achieve what I'm trying to achieve in the future. So the clinic is my favorite place at the law school. I truly love it, and I value my time working there.
Thank you very much for those kind words, Daniel, and Camille and Justin as well for describing the work. We've had some questions come in, so we'll take those in a couple of minutes and give you a chance to talk a little bit more about some of your experiences as well. What I wanted to do first was just say a couple of additional points to kind of circle back on some of the context for the work that we do and student trajectories. So what do students do after their time in the clinic? So as Daniel was mentioning, we have a lot of other projects going on. We have a lot of other very active litigation these days. So some of our work relates to the Federal Clean Water Act. So generally speaking, under the federal environmental statutes, Congress crafted those statutes so that if a company typically or a person is violating the statute and the government is not enforcing the law, then citizens can step forward and sue. They have to provide notice, and there are a number of procedural steps they have to kind of go through first that are designed to trigger government action. And even if the government interacts procedurally, citizens can then intervene in these cases and still have a seat at the table. So on the upper left, we actually work, that's a picture of a person surfing in Lake Michigan. So people coming from the other coasts may not realize or appreciate, but we actually have surfing here at the southern end of Lake Michigan, which is also where there are significant refineries and steel plants. And so we've represented a group of surfers suing the US steel plant, which put more than 300 pounds of hexavalent chromium, a significant carcinogen, into Lake Michigan. Kind of down diagonally from that, Trump Tower has illegally taken water from the Chicago River, and we're working kind of in conjunction. We intervened in a case that the Illinois Attorney General is bringing there. As Daniel mentioned, we are working in East Chicago, Indiana. About 2,000 people live on a highly contaminated Superfund site, highly contaminated with lead and arsenic, incredibly high blood levels for the kids there. And so we've been working there for the past 4 years with local residents. We're in the midst of litigation trying to protect the imperiled Lake Sturgeon, species that's existed from the time of the dinosaurs, that's really under threat right now. And Fish and Wildlife Service has been delaying and dragging its feet, really keeping the fish stuck in an administrative quagmire. And then kind of back to Northwest Indiana on the far right there, working to help protect the Indiana Dunes National Lakeshore and help to see that when it is expanded over time, that the environmental contamination is basically dealt with before the expansion kind of takes place there. So in terms of the student trajectories, what you see is that students have clerkships. They come out and they get high-level clerkships for the U.S. Court in the U.S. Courts of Appeal and district courts. We have a postgraduate fellowship that we have donors who are very generous to help ensure that we've got an environmental postgraduate fellowship for those who are particularly interested in this, as well as general environmental. And then we've got students get permanent positions with top environmental NGOs like Earth Justice, NRDC. Some have gone to work at US EPA, Environment and Natural Resources Division at the US Department of Justice, Illinois Attorney General's office, other clinics, and obviously top law firms as well. I think it was Justin who said this. You know, we really have a big tent view at the clinic. We want students who come who are interested in environmental issues, energy issues, but are also really interested in just gaining good litigation chops and policy skills as well. I have to sort of close the formal presentation with that picture, which I'm so proud of, because it highlights the students as well. So what you'll see there is that you'll see myself on the right and Rob Weinstock there, second from the left, and three of our students. The student in the middle, Lisa Frasco, was in the process of arguing a motion in circuit court in Madison County, Illinois, over an illegal discharge into the Mississippi River. The students who worked on the project were Carrie Shepard on the left and Lauren Piet on the right. Lauren now works at Earth Justice in the coal program. Carrie works at the Northwestern Environmental Law Clinic, and Lisa Frasco just joined EPA. So we're really proud of the students who've gone off to careers in this field, but also proud of all of our students who are working in the field. So I am going to, our current students are also, looking for opportunities, permanent opportunities. So if anybody has those opportunities, I will be happy to connect you with those students as well here. So I now want to turn this over to some questions that we've gotten. And maybe one of the good transition questions will actually be to talk a little bit more about the difference, how are students involved in the Michigan work and how the Michigan PSC treats that. And then, I don't know, Justin, student involvement in the amicus briefs. I mean, DC Circuit, student involvement on that. So maybe Camille and Daniel, you want to talk first about kind of how students get engaged and how the public. Daniel, maybe you want to talk about this because I think you were one of the first to actually do a cross-examination. Then Camille, you can say a little bit more, and then Justin kind of talk about, you know, the DC circuit and things like that for student engagement.
Sure. Yeah, the Michigan work, Michigan has a statute on it. It's actually pretty straightforward. You have to just be in good standing with your law school in order to participate. So we just worked with the registrar's office at the law school, and they wrote a letter for us that we submitted a motion with. And our adversary, DTE, was really receptive. It was interesting. The chief attorney for DTE was pretty open to it and said, "Oh, I worked in a clinic in law school also, and I'm very supportive of clinic work." They didn't really have any issue with us participating in cross-examination either. I think the one stipulation was that the professors couldn't follow up and sort of pick up any of the pieces we might have left behind. So it was really like one opportunity to cross-examine, one bite at the apple, if you will. But the process for participating in Michigan's actually, it was even easier than like a 7-Eleven license, which is sort of a provisionary license to practice law.
Yeah, I would say the same. Everyone that participates in the Michigan proceedings is very receptive to students. We often meet with other parties, other interveners, and they'll ask our opinion and are very receptive to working with us. So in Michigan, we're lucky to be able to have those opportunities, and the regulators are very respectful and also really recognize our points and often respond to them in their decisions.
Yeah, I mean, just to underscore, you know, there's a specific provision in the Michigan administrative rules that allows for student practice, but it seems that no one had ever done it until we actually did it. And so in fact, it raised some questions and some conversations. And to me, it was really important. I mean, you know, I think our work in the clinic has to be at least as good, if not better, than outstanding work that other people are doing, right? Being a clinic means that there are higher expectations that we need to have for ourselves. And I think that the students have excelled and exceeded those expectations. And it made me very proud kind of in the sidebars afterwards with other attorneys and with the administrative law judges to get their compliments on the work that the students did during the cross-examinations. So, and Justin, in terms of the DC Court of Appeals and student involvement, do you have comments?
Yeah, the DC Court of Appeals was last quarter when we were dealing with the ACE litigation, very amenable to students being involved in the process. On the brief page where it lists who worked on the brief, we had both Mark and Rob's names on the brief, but also the students' names who worked on the brief as well. So we found no major problems with the DC Circuit filing as students, and we believe that the court treated us as full lawyers and respected our opinion and took in our advice, and it went off without a hitch.
Great. Hey, Justin, and maybe Daniel too. I mean, I see, because of your work on the social cost of carbon, I want to pick up on one of the social cost of carbon questions that came in. It was, how do you see the social cost of carbon being refined in the future? You know, maybe is there a consumer aspect of that, which is not something we've worked on per se, but maybe you can kind of talk about what you know about how the social cost of carbon is being refined and maybe other aspects of this.
I can start and then
yeah, why don't you start? Yeah,
I'll start and then we'll see if Daniel has anything to pick up. So the social cost of carbon has been refined multiple times over its lifetime already. One of the main kind of foundational moments was in 2009 when an interagency working group in government created the social cost of carbon, formalized it. But in subsequent years, basically every 2 or 3 years, the same working group has returned to the social cost of carbon and tried to improve its calculations, improve its assumptions, improve what sort of inputs they're putting into the models, improve the models themselves. So this is not something that's static, that stays in one place. The economists and the environmental scientists who are working on this are constantly trying to improve it and make it, you know, as accurate as humanly possible. I personally don't know to what extent it might be useful in the consumer space, but I will say that the social cost of carbon is designed to capture the harms from a ton of CO2 emissions. And in theory, that shouldn't matter what the source is, whether we're talking about coal plants or we're talking about how much CO2 is released when a t-shirt is produced. Whatever it is, this metric should be useful. And whether this scales down to the individual consumer level or not, it's certainly a metric that can be used whenever you're dealing with some sort of harm associated with carbon dioxide emissions.
I think I'll just add, and these are my own views, but it matters what administration is in office, the prominence of the social cost of carbon. So depending on what happens in 2 weeks, we will see what happens with the prominence of the social cost of carbon. Because as you saw in Justin's presentation, where we're at today is valuing the ton of carbon dioxide as $1 when science shows it as $40, $50, $60. So whether it's actually incorporated in rulemakings or people like the clinic continue to litigate the issue and force the issue is sort of a big question as to its utilization. And I also, on the side, I wrote a journal article about environmental disclosures on consumer products and there are other places in the world where there's already a energy score or a consumption score on candy bar wrappers and things of that like. So I believe New York passed an ordinance that you had to post the energy consumption on buildings larger than 10,000 square feet. So this kind of logic is starting to creep into play, and I think it's beneficial and can only continue to increase.
It's a great question, and honestly, these are the kinds of ideas and discussions that we really value, because we really, I think, understand as best as lawyers can how the social cost of carbon works and should be used, but there are really lots of other opportunities. And again, I think as Justin said, I just want to underscore, right, there are a lot of people working on climate issues because it is the biggest problem, existential threat and challenge I think we face, or at least one of the top couple that we have. And we want to make sure that students have a meaningful role and are not the, people who are kind of, down low on the chain and not really contributing to it. So we've tried to figure out what's the piece of this puzzle that we can really contribute something to. That's where working with Professor Greenstone has really been valuable. And again, as Sean Donahue said, we're kind of making a real contribution there in some of these big pieces of litigation that are the regulations that affect basically 85% in total, 90% of US greenhouse gas emissions, really bringing a U Chicago kind of internalize the externalities perspective. I'm looking at one of the other kind of questions here. I guess there was kind of a question, maybe one more social cost of carbon question, and then I can kind of shift back to the Michigan questions here for a second. So Justin, there was kind of a question about the global aspect. And so one of the big debates is this kind of global versus domestic. And can you just say a little bit kind of more about that, what it is and why that's important? Not just from a dollar perspective, but kind of, I mean, that is part of it, but kind of more than that too.
Yeah, so I mean, I'm sure that most people in this presentation are aware of the fact that climate change is a global problem. Greenhouse gas emissions do not just hover above the United States and affect only US citizens if they're produced in the United States. They affect the whole world, and the emissions of other countries also affect us. So one of the main arguments that we made in ACE litigation, again, challenging the Trump administration's rulemaking regarding power plants, was that this is a global problem and that the social cost of carbon needs to incorporate the harms that accrue outside of US borders as well. So there are a few different ways that emissions from other countries kind of affect us. But one of the ways that we've talked about a lot is that US disengagement with global climate leadership has reciprocal effects on other countries. So when the US disengages from leadership on climate issues, other countries also disengage. So, the mere fact that the Trump administration repealed the Obama era Clean Power Plan, replaced it with a much less stringent rule, had the effect of other countries kind of receding on climate issues as well. So we're very much aware of the fact that this is a global issue, and we try to bring that sort of perspective to the forefront whenever we get the opportunity to make that argument.
Right. So there was a comment, maybe Camille, that you could react to, or Daniel as well, given the Michigan work. We have a comment about glad to see your work in the Michigan Public Service Commission proceedings. I will admit that some people don't even really fully understand what these public service commissions are. And so the commenter said, I've been involved in rate cases in Wisconsin, and these decisions have big impacts on people and the environment, yet few people understand the process. Could you maybe just say a little bit more about that, Camille? Because it sometimes can feel like it's, I don't know, really inside baseball, you might say, and what it's been like working on these cases. And, Daniel, you can add as well.
Sure. I think I'm on, this is my third or fourth case in front of the MPSC that I've worked on, and really, like, institutional knowledge is a huge contributor to your success in these proceedings. I think Mark and all of us have talked about this multiple times. When you first come in, there's a lot of stuff you just don't know or don't understand. And every time you go through a case, you realize that there were these other things that you didn't know about. And so now that we have been in these proceedings for a while, I feel like we've finally gotten to a place where we're the proactive party versus the reactive party. And that's really exciting for us, because now we feel like maybe we can take some bigger steps or larger risks than we would have before, and make some more important arguments. So I definitely understand where you're coming from. It's something that takes a lot of time working on these things to really get to a place where you feel like you're making a bigger difference.
I'll just add two observations sort of on the inside baseball point that Mark added. If you want to end coal-fired power plants in America, you're likely going to need to do it through a public service commission or something along those lines. And so you pull back the curtain on this sort of, it's a boardroom, it's not a courthouse. Coming off of first year civil procedure, walking into a administrative public service commission proceeding, the standards of evidence are different. Just the process is different. It's a lot less formal. So it's very interesting that these really critical decisions are made sort of in nondescript bureaucratic office buildings, as opposed to a courthouse or what you expect after your first year of law school.
Yeah, I mean, I would add, it's again, these are very kind of, I think for decades, right? The public service commissions were largely rubber stamping what the utilities were doing. And frankly, because there were scale economies, the prices kind of kept going down as we were kind of building out this big energy infrastructure. And then particularly recently, when I say recently, in the past decade, the environmental organizations, decade to 2 decades, have, as Daniel was saying, really realized that this is where the rubber hits the road, where the public service commissions are approving the building of, now it's about the building of new natural gas plants, which emit fewer pollutants than coal-fired power plants, but still about half of the CO2 as a coal-fired power plant. And we just see from the kind of experience with coal that you really lock in the infrastructure. So it's really important to kind of get in there. And these are long-lived, decisions worth hundreds of millions, if not billions of dollars. So really kind of critical if we're going to pivot towards a cleaner energy future. This is, so maybe another question related to that. Carrie Shepard, who actually was one of the students highlighted in that picture, has asked, what role does the declining cost of renewable power play in the Michigan proceedings? So Camille, Daniel?
I wish it played more of a role, to be honest with you. Utilities, especially really, really large utilities, are sort of behind. And so they're still paying for investments they made 20, 30, 40 years ago. And so we often argue that costs should be cheaper as renewable energy has become cheaper, and renewable energy should be the focus. That's kind of our place in the proceedings. And so I think it's becoming more and more sort of mainstream. Renewable energy choices are becoming sort of the first choice, not the second choice, and that's what we want. But utilities are definitely behind the general populace in making those decisions.
I think it would have been helpful entering these proceedings to have a background in accounting, because I think what it often comes down to is how utilities account for the costs of either renewables or their LNG or coal-fired plants. So for instance, in some of these Michigan proceedings, there's no accounting for the costs post-shutdown and reclamation of a coal plant, or they'll discount the lifelong benefits of a wind project or a solar project because the span of their analysis is only 20 years. So a lot of it is sort of picking apart the ways that they put the thumb on the scale for their traditional sources of energy, which is difficult because, as you said, the cost of renewables is going down and it will continue to go down. So if it's not in parity today, it's going to be in parity in 5 years. And in a 20-year integrated resource plan, this gets me worked up, because in a 20-year resource plan, there's just no justification for continuing to bang your head against the wall with fossil fuels against renewables.
It is hard not to get worked up. So Daniel, I appreciate you sharing that. It's just to circle back to the voluntary green pricing case that Camille mentioned that we're currently in. Right now, the company, DTE, but others, this is true other places too, are basically saying, if you want more renewable power, you have to pay extra. And that's because of their investment in these legacy assets, and they have to cover the investments in those legacy assets. It's not about what the cost of the new renewables is. So I agree with everything that they have said. I want to be sure to give time to my colleague, Rob Weinstock, who is just integral in really helping to work closely with the students here. I'm going to see if we can spotlight you here, Rob, just to say a few words about your perspective on some of these issues too.
Thanks so much, Mark. And it's just such a joy to hear Camille and Justin and Daniel talk about our work. We don't often get to step back and do it in this format. So this has just been, I've had a big smile on my face this whole time. So thank you to the students, and thank you to everyone else for joining us. I just want to come back around to something Mark said at the beginning about what our students go off to do and how we view our role at the clinic in helping them on their career paths. I come from before joining the clinic, I came from a private practice background where I was focused on complex litigation, both general litigation, commercial litigation, as well as environmental work for a number of years. And what I see is our students really gaining the skills that they can take into those settings, as well as the nonprofit or government service setting. And there's really just three things I want to highlight very quickly. One is they learn quite a bit in their doctrinal classes in their first year and thereafter. When they come to the clinic, we focus on practical research and writing. These are skills that students are not getting in other environments until they go out into the workforce. We are doing that work with them here. I think employers from all over the country, really in lots of different settings, really come to value that piece of their education we are providing. Specifically in some of our clean water work, and I know one of the comments asked about how we develop our facts in our clean water work, we do work with experts, and that's a unique opportunity that the clinic gives to students, is working directly with subject matter experts, engineers, scientists, economists, as we've heard about in the social cost of carbon context today. And finally, I think what we teach them really is problem solving and how to work with clients and allies and others and adversaries in the real legal context in which we work. This is hugely important. Another commenter talked about presenting to boards or other presentations and other forms of advocacy. That is something we do all the time through presentations to stakeholder groups, presentations to regulators, work with regulators on policy issues. So I think that is integral to what we do in the clinic. As I was thinking about what I've heard today, I was reminded of sort of the old trope that people use about the first year of law school, where everyone says, oh, it's boot camp where they teach you to think like a lawyer. And I think there's some truth to that. I'd like to think that what we do in the clinic is teach them how to write like a lawyer and act like a lawyer too. So they know how to channel all that knowledge that they're developing with us, but more broadly as well, of course. So thank you so much for joining us today. Thank you again to the students and to Mark. This is always a pleasure to talk about our work.
Great. So I think we are getting kind of close to time here, and I just wanted to say, I guess, a couple of wrapping up remarks. I mean, I think the way, as Rob was saying, we kind of think about this from early on, from when students express an interest, and the University of Chicago Law School, right? Even before they come here, we are trying to reach out to the students who are interested in environmental and energy issues, and any student interested in these kinds of public interest litigation, public interest work kind of more generally. Work with them when they're first years to help them find summer jobs, summer internships, then work with them in the clinic. We and our colleagues have doctrinal classes, and then help them to launch, give them the clinical experience you've heard about today, and then kind of launch them into their careers. So we really think of this, you know, Camille had the circle flow. You know, there's a similar way for us where we are always so excited to have this opportunity to work with the new students and to see the students here. I mean, Justin, Daniel, and Camille are incredible. They were incredible before they joined the clinic. It's been great to see them progress over the past few quarters and to see the kind of work that they're going to be able to do. And I just want to say how grateful I am to people who have supported and who helped to launch the clinic, who've supported us through, you know, financial contributions, but also great ideas, great contacts, helping us build our network, helping us find great clients, great cases. This really is a network, a community of people who care about these issues. We didn't touch on all of the questions. If you want to email me, I'd be happy to follow up with you. I will be 100% honest that we have a reply brief due on Friday. It's a little consuming, so it may take me a couple of days because I've got to fulfill those client obligations first. But we would be happy to be back in touch with you if you want to follow up with us on any of the questions. You know, one of the silver linings of Zoom is that it's been a real opportunity to highlight Daniel, Justin, and Camille. And so I'm just so grateful for them. So could you please join me in a round of applause for them, and thank you for all your interest and support in the work of the clinic.